Hello. I really need to fix how that intro ends. We'll get to it one day.
Why? What's wrong with it?
It has a fade on it, so it just fades wrong. It drives me crazy, but I just haven't had a chance to, redo the fade.
Hopefully I'm not freezing.
Just for a second. It's good now. How are you?
I'm doing good. How are you?
I'm good. All right, so I'm gonna refresh the stream and just keep refreshing. I don't know if you guys know, I'm doing well. I was gonna try and do this with a different program, but I couldn't figure out how to use OBS in one day. It's like
yeah, that's I still have to try and tackle that animal. It's
I got it today, and yeah,
you need some time, that's for sure.
Yeah, so usually StreamYard doesn't work well with a VPN, but that's the only way I can access this hearing. So we're trying it, and it seems okay so far. I think.
There's got to be a picture of the sheath other than in Maddie's room.
I guess so, yeah. I know that when it comes to, the situation with this temporary restraining order, it has limited, pictures of Maddie's room in particular because Karen Laramie was the one to start the lawsuit. So a lot of people wanted to see the sheath where it was found. So, yeah. We'll see how that's going to go.
See, I don't understand. You don't have to show Maddie. You could literally crop out, you know what I mean, the rest and just have a soiled blanket, if it is even soiled in that spot, and still show the sheath where it's at. I don't understand. I get if she doesn't want, I wouldn't want my loved one to, for people to see the graphic pictures, of my loved one, because then I have to live through that, and I'm already trying to move past that. I get that part, but the sheath itself, I think it should, because there's so many questions, even in the documentation of exactly what about the sheath. There's so many questions already, so it don't make sense.
Yeah, I agree with you. Look, I do appreciate and understand what they're going through, but I think that I think it's important for people, like if you think about how this case has gone and how suspicious people have been from the beginning, I think that it's important for people to be able to see as much as they can with this particular case, just to put it to rest properly. If that makes sense.
Well, I mean that there's no trial. He confessed. It's over. So they should be part of a FOIA. It doesn't make sense to me.
The hearing has started. I think that we are a little bit behind, but I'm just going to share the screen.
I just don't think they want to show how they seen it from the doorway, because I don't think that took place.
Starting with Mr. James. Mr. James, were there any sort of objections that you had to the declaration that was submitted by the city in this matter?
No, Your Honor.
Mr. Plascal, any objections on behalf of the city to any of the declarations that were filed?
No, Your Honor.
Okay, then I believe we can proceed with argument then. Mr. James, you may go ahead.
Thank you, Your Honor. May it please the court, Leander James, pro bono counsel for Jim Chapin, Stacy Chapin, and Karen Laramie. I will not reiterate everything that is in the briefing, Your Honor. I know you've reviewed it and carefully. I do want to touch on several subject matters and emphasize a few things. The subject matters are the facts of the case, the uniqueness of the case, and the application of the law to these unique facts. The facts. The city contends and has sworn testimony that it redacted all of the bodies in the case. We submit respectfully that that is factually inaccurate. Blood, as a biological fact, is part of the body. There are portions of these images that show, without any blurring, pools of blood, splattered blood, dried blood, smeared blood. Blood is part of the body. It is factually inaccurate to say that the bodies were entirely blurred. The blood, of course, most of it we see in what we call in the law the death scene images. Here are the bedrooms. There are also images of blood, that splattered blood and other blood. It looks like in images I reviewed, the representative sample, there was splattered blood outside of the bedrooms. What has been sent out, unfortunately, has been sent out, but any further dissemination of information should include complete redaction of all the blood. That's part of the body. Second point I wish to emphasize is that blurring is not redacting. Your Honor has in the record, for example, in the testimony of Stacy Chapin, how incredibly harmful and emotionally damaging it is for her to see images of her son and the other murder victims that are in these images that were released and that may be released. They're in there. They're just blurred. They're just harder to see. The city could have used a black box. They could have truly redacted. But the definition of redaction, which I put in the brief, is that all of the sensitive material is taken completely out. It's not that it's blurred. So we would ask that as part of the order that the city be required to, with any further dissemination, the portions that are redacted are completely blocked out and not simply blurred. The uniqueness of the case. This case is unique in a couple of really important ways. One of them is that it's, as the court has acknowledged, it has garnered worldwide attention. Because of the true crime industry, which is a multi-billion-dollar industry, and because of the prurient interest of others and the economic efforts of bloggers, the information in this case has been disseminated, used, misused, and used in ways that are incredibly harmful both to the witnesses, others involved in this case, and my clients. I understand under Idaho law that the city cannot ask a requester why they want this information. And I understand that it's not part of the court's analysis of why are they asking for this information. However, I respectfully submit that the context of the World Wide Web this day and age, in fact, the technology this day and age, is relevant to the analysis of the impact on my clients. So while I understand the court and the city is not going to look at why is someone asking for this information, in the context we're in today, I think it's relevant to understanding the impact on and the invasion of privacy. And I think it's fair to analyze using that the reality of the situation we're in today. And it's unique for a couple of reasons. Because of AI and other technology that's far over my head, images like this are disseminated within an instant worldwide. It's something we've never had before in history. And the true crime, another prong of that is this true crime sort of, industry that uses this stuff for economic gain and misuses it. And then a third prong of it is that the reality is that people who comment and look at this stuff say horrible things about the family members and others. So I think the context there is important, the uniqueness of the case. Application of law. There are two overarching theories that we put now, arguments we put in front of the court. One is the statutory right to privacy, and the other is the common law right to privacy, which is recognized in Idaho under the Urenga case. A few comments on the statutory right. I think one of the key issues under the statutory right is, there are others, but one of them is who qualifies as a victim. And the court can interpret the statute to determine whether my clients qualify as victims. Now, I think a reasonable interpretation is they do qualify as victims. They were victimized in two ways here. They were victimized first with the murder of their child and sibling that deprived them of the love and affection of the murder victims. It's tragic, and it happened. They were then re-victimized when these images, these gory images, were disseminated to the public, or at least in this case to one media outlet that then apparently disseminated to others because they're now out there everywhere. And my clients have seen some of these images, and the court has the record. It's been a devastating loss to them. They were re-victimized when these images were sent out to the public. I am respectful of the city, and am quick to add, I am not implying and do not mean to imply that the city had any intention to victimize these people. I do not think that. And my clients remain grateful to the Moscow Police Department for everything it's done. But in terms of analyzing who's a victim under the statute, I think it's relevant to recognize that my clients were re-victimized. And I think it's not a reasonable interpretation of the statute to determine they're not victims under the IPA, because it's consistent with other statutory, other Idaho code provisions that recognize the immediate family members of a decedent. They recognize that they have victim rights. In IC 195306 is the victims' rights statute, and it explicitly recognizes that family members have rights of the victims. The application of law here, I think, first of all, in conclusion, under the statute, I think the clients qualify for protection from unwarranted invasion into personal privacy. They also qualify under the subsection small I to not be harassed by dissemination of this information. And again, whether intended or not, the dissemination of this information results in harassing them with emotional damage. So I don't think you can just analyze under subsection 2 I. I think it's important to look at single I. Even if the court determines, which I do not think the court should, that, well, let me back up. Another reason under the statute why my clients here should be protected was laid out in the court's original analysis in the TRO and in the Gaylord case, which adopted the Gaylord analysis in supporting cases, including Supreme Court cases that recognize that when an individual dies, the immediate family members, the right to privacy of the decedent inures to the benefit of the immediate family members. And the court knows that analysis. The court has thoroughly gone through it. But that also applies here. So for all those reasons of the statute, I think my clients should be protected. Even if the court determines they aren't protected under the statute, which I think would be incorrect. But yeah, if that happens, there still is the common law right to privacy that's alive and well in Idaho and a basis for granting the injunction here. So in conclusion, and that right to privacy specifically includes intrusion upon the plaintiff's seclusion or solitude or into the private affairs. What is more of an invasion here of the parents and the siblings' seclusion, solitude, and private affairs than to disseminate death scene images of their children worldwide? The last thing I want to say on the statutory side, I want to go back to statutory because I meant to emphasize this, Your Honor. The IPA puts an affirmative duty on the city to, once a request is made, they have an affirmative duty within a certain period of time, depending on where the requester is requesting from. They have an affirmative duty to determine both what should be released and what shouldn't be released, what's subject to the exceptions. I understand that, well, that's the statutory scheme. That's what it says. It's plain language. The analysis of the city, and by extension now the court, is triggered by a request. And they're determined what is exempt and what isn't exempt under the statute. It is not triggered by an aggrieved individual under the statute coming forward and filing a lawsuit. That's not required. And my clients, and I believe that under the statutory scheme, this analysis is not just limited to my clients and the death scene images and their rights to privacy. They extend to all others who would fall under protection under both the common law and the statutory scheme. And I give the example in the brief. I'll just say it so everybody can understand where I'm coming from. Imagine a body camera video, a police officer entering a house, investigating a crime scene, and they run across a girl, a naked girl, coming out of a shower, and happen to film it. Now, I don't think any of us would reasonably argue that that should be disseminated to the world. That girl has a right to privacy, and it shouldn't be disseminated. And under the Gaylord case, we use an objective analysis. Would a reasonable person see that as an invasion of privacy to disseminate their images of their naked body to the world? Yes. And it's an affirmative duty on the city in that example, were that to happen, to redact those images and protect the girl from the unwarranted invasion of privacy. So my clients respectfully submit that the analysis here extends beyond even their children and sibling, but to others, including witnesses and others. Now, implicitly, the city has acknowledged that analysis because they blurred images of the face of witnesses and others. So they've redacted, or again, it's not redacting, it's blurring, but they blurred certain things of other people, and I think that implicitly acknowledges what I've just argued. In conclusion, Your Honor, we respectfully submit that a permanent injunction should be entered, preventing any further disclosure of the death scene images, any further disclosure of the bodies, including the blood. That should all be redacted, any image of blood. And we would ask that the court also consider what other images are an unwarranted invasion into privacy or an intrusion upon the individual's seclusion, solitude, or private affairs, because we think there are others there, but clearly the core ones that are, we think are over the line are the death scene images. Thank you, Your Honor, and I'm happy to answer any questions.
Thank you, Mr. James. Just
My
a couple
lord.
of follow-up questions here. So, in your complaint, your clients seek a privacy interest in a number of different parts of the video, to include not only these, as we call them, the death scene images, but to include also the images of witnesses, the sounds or the audio related to those witnesses, any media containing the sounds of the witnesses, and what they may or may not be saying as far as just the sobbing portions or them crying. So my question is, but then in your briefing, it didn't seem to address some of that. So I was wondering, at this point, are your clients still asserting a privacy interest in the images or sounds of witnesses? And if so, where is that? How do we get there as far as their privacy interest is concerned?
Yeah, good question, Your Honor. I'll answer. That links back to what I said about the affirmative duty under the statute. It's our position that the city, and by extension now the court, has a duty to analyze these images and these audio sounds to determine whether exemptions apply to those two. Now, clearly, those images and audio sounds are triggering for my clients and cause intense emotional stress. I think it is the question I think the court's getting at is, well, how is it an invasion of their privacy? And I would respectfully submit that's really not the analysis. The analysis is once the request is made, then it's the obligation of the city to analyze whether disclosure is an unwarranted invasion into the privacy interests of the person. That's why I gave the example of the naked girl. The naked girl, so to speak, is not here making a claim. No witnesses have come forward and made a claim. They don't have to. The statute asserts an affirmative duty. And so our position is that the city, and now by extension the court, because the court's now in the middle of this, it needs to analyze these images and audio sounds to determine what is appropriate or what is exempt and not exempt under the statute. And also there's the common law interest of right to privacy. I think that should be analyzed. And I'll just emphasize it. Nobody has to come forward and do what my clients did, find an attorney who would be willing to file a lawsuit for them and go to this extreme point of bringing a case. They don't have to. The statutory language is clear. The affirmative duty is on the city to determine what is exempt and what isn't exempt regarding all of the images. Thank you, Your Honor. I hope that answered the question.
Yes, thank you, Mr. James. And then the other question I have is that just before I turn over to the city and having reviewed what their briefing includes, if the court were to find that the family members here or the plaintiffs do not have a privacy interest, then do you maintain that the deceased individuals themselves have a privacy interest? And if so, to what extent?
That's a great question, Judge. I think under the Gaylord case and the cases I've analyzed, the privacy interests of the decedent still exist, but they inure to the benefit, as I said, to the family members to assert them, and they have a right to assert them. So I think that it's sort of how you slice it here. I mean, you could, I think, analyze it in a way to say that once the decedent dies, their privacy interests die with them, and the family members have a privacy interest. But I think it's fair to analyze it under the case law that the privacy interests of the decedent then are exercised by the immediate family members. So that would be the position I take, Your Honor, on the law, that to really refine it, there are really two privacy interests at stake here. One is the privacy interest of the decedent that is exercised by the immediate family members, but they're also the privacy interests of the immediate family members.
All right, thank you. Mr. Pascal, response?
Thank you, Your Honor. Your Honor has obviously reviewed our brief. I'm happy to answer any questions that you have about it, but I will be brief in my comments. I don't have a whole lot to say beyond what we have argued and laid out in our brief. I do have a couple of points I want to address that Mr. James raised, but at the end of the day, the city's the man in the middle here. If there were an option set forth in the statute that allowed these records to be fired into orbit, into the sun, I think, in my heart of hearts, and I'm pretty sure Ms. Batista's as well, we would just as soon not release these records. Nobody gets them. These are harrowing images. This was a horrific crime. I don't think that anybody could reasonably say otherwise. And I equally think that it would be difficult, if not impossible, to dispute that family members of victims of a crime as horrific as this, of course they are distressed, will be distressed, would be distressed by the release of any materials relating to the crime. I can't dispute that. I don't want to dispute that. And the city has not to this point and does not intend to dispute that. The declarations that Mr. James has filed on behalf of his clients lay out in sufficient detail that his clients will find the release of these materials distressing. That's not in dispute. The problem is the way the statute is written, at least as I understand it, and as I know Ms. Batista understands it, there's equally little dispute that the materials we're talking about here qualify as investigatory records under the Idaho Public Records Act. And there are several exceptions. There are several exceptions written into the statute. Existing case law says they are to be construed narrowly. And to the best of my knowledge, the only exception that has any plausible application to the materials we're talking about here is the unwarranted invasion of personal privacy exception set forth in, I don't have the code section in front of me, but I can pull it up in just a second. Should have had it in front of me, my apologies. Set forth both in Idaho Code section 74-124, and the definition of personal privacy is further defined in section 74-101 sub 17. And to follow up on the court's second question to Mr. James, that is, I don't know, it might be the crux of the matter if Your Honor reads this provision and gives it its plain and ordinary meaning. It defines the right of, who can raise this privacy interest in a fairly narrow and restrictive sense. I don't dispute that it was written against the backdrop of the common law. And I also don't dispute that if we go look beyond Idaho, the United States Supreme Court has discussed, what I understand at least. It's not entirely clear from Justice Kennedy's opinion, but I understand him to be talking about the common law right of privacy there, that the federal FOIA statute was written against as a backdrop. But the statute itself in Idaho is quite narrow in terms of the privacy interest that comes into play when you're talking about the right of privacy or unwarranted invasions of privacy for these purposes, for purposes of reading this narrowly construed exception to public disclosure of investigatory records, which again is required by statute in Idaho, for good or for ill. And I'm not going to go through what I wrote in my brief. Your Honor has it in front of Your Honor has it. If you have any questions, I'm happy to answer. But the bottom line is the type of privacy interests that are talked about in Idaho Code 74-101 sub 17, they don't clearly apply here. The only interest that is talked about that might, I think, is, in terms of interests of deceased parties, it uses language that is not applicable here. And the other section that applies, or at least has plausible application, is the provision that talks specifically about unwarranted invasions as weighed. It imposes a balancing test. I don't know how you can read Idaho Code 74-101 sub 17 and not come to the conclusion that you can find a privacy interest. You can find whether it inures to the benefit of the deceased, the victims themselves, the family members, whether they are victims themselves as a matter of other statutory provisions or not. It's still a balancing test. Whoever, whether it's the city or a court that is brought into the mix, has to weigh the competing interests. And the competing interests are the interests in privacy, which, whether you find that the family members that have brought suit here have an interest in privacy or not, it still has to be weighed against the interest in public disclosure. And as I've also set forth in my brief, the city has received numerous requests for these materials. The city has received almost more than 1,150 total, and 250 of them specifically asked for images, body cam video, whatever. I may have the numbers slightly wrong there, but the bottom line is the city has received, at minimum, a couple hundred requests that cover investigatory records that include photographs, videos, whatever else the city's officers collected when they responded to this crime and investigated. Whether I personally, whether anyone personally thinks these images should be released or not, the city has a duty under the statute to release them on request, unless an exception applies. And as even Mr. James acknowledged, the city doesn't get to ask why. The city doesn't get to look into, quiz the requesting parties on why they want these images. And for lack of a better word, I struggle to understand why members of the public want these images, but I am not the one who's made these requests. And equally, I unfortunately know that we live in a time when conspiracy theories, and as Mr. James referenced, the world of true crime, it's a big business, it's a big industry. Conspiracy theories run rampant, and as I cited in our brief, there are a small but vocal segment of individuals who, even after Mr. Kohberger pled guilty, admitted his guilt, admitted responsibility for these horrific acts, they still think that he might be innocent. I don't know what there is to say other than the reasons why any individuals would want these images. It's difficult for me to wrap my head around. But that is, unfortunately, under the way this statute is provided and written, that isn't the question. The question is whether the public has a right to look at the affairs of the public officials that run the government, investigate crimes, and prosecute crimes. There is no investigation ongoing. The city can no longer say, look, we can't release these. There's an investigation ongoing. It will impede the administration of justice. For good or for ill, the materials have to come out unless an exception applies. And the only exception that applies here is one that requires a balancing test. And as far as I can tell, the city applied that balancing test to these images and crafted what I think is the only sensible balance. The materials that the city has provided to the court, the initial redactions, and Mr. James characterizes blurring of images as not redactions. I don't know how exactly to respond to that. If they're not visible because they're blurred, or if they're not visible because there's a black block over them, if you can still see the rest of the room, that seems like a fairly trivial distinction. If the court intends to issue an order that requires that black boxes be imposed instead of blurred images, Ms. Batista can correct me if I'm wrong, but I think that the city would be probably amenable to that. I don't think that that is a hugely burdensome issue. Whether other parties that have requested the images would object, I don't know. The city could end up back in front of Your Honor or in front of some other judge in this district saying the flip side of this argument, which is to say, well, blurring is good enough. Why didn't we get the blurred images? Why do we have to look at black boxes or something similar? As I said, the city is in the middle here. The city is going to get it from either side, and there doesn't seem to be any way to avoid that. As far as Mr. James's suggestion that images depicting blood spatters or blood pools are body parts, I don't know. I don't have a particularly, I don't know how to respond to that, simply put. If I'm cut and blood ends up on the floor, I don't think that is part of my body anymore. I know that there is a fairly extensive body of intellectual property law that gets into residual interests that individuals have in, for example, blood or DNA once it's removed from them. But to say that images of blood spatter is tantamount to and no different from a depiction of a dead body on the ground, I don't think that's a strange argument, and it's not one that I agree with. I don't know how exactly to respond to it other than to say I don't think it's accurate. I don't know how much else I have to say, Your Honor. At the end of the day, we are talking about an exception that requires public officials to conduct a delicate balancing test and weigh the public's interest in disclosure and the interests of family members or the deceased, depending on who exactly it is who holds the privacy interest, and release the materials that the statute requires to be released. I think the city did that here. If the city came up with a balance that is not completely where the court thinks it should be struck, we will accept your guidance. I mean, I don't think that there is necessarily anything in the statute that says one way or another whether a public official's application of this balancing test is due any discretion or due any deference. At some level, it's inherent in any type of judicial review of administrative or agency actions. But I mean, we're not here on a petition for judicial review. We are here under a request for injunctive relief or, I guess, declaratory relief of some sort. And the statute doesn't provide any clear guidance. I would simply say that the court should, just as a matter of principle, defer to the considered judgment of public officials in this area. But at the end of the day, weighting evidence is something that the court is very familiar with. That's what courts do on a daily basis. Whether that means that every particular decision made by the city in this case, or any other case in terms of disclosure of investigatory records, needs to come in front of a judge to be reviewed and ratified, I don't know. That doesn't seem like the scenario that the legislature envisioned, but perhaps it is. And I'd just like to conclude by saying that Mr. James suggested that this is in some sense a unique case. I don't think that's necessarily true. I think, unfortunately, a lot of the interest that he was referencing, the fact that the internet means that disclosure instantly makes whatever is released, it's around the world before the opposing party has their boots on. I mean, Your Honor is aware that my office was brought into this case very late. I wouldn't even say late. The process has been ongoing. We were brought into the case right before the lawsuit was filed. I've since reviewed the images. I've since reviewed the body cam videos, both in the initial redacted form prepared by the city and in the additional redacted form prepared by the city after the TRO was issued. This is not an easy case. I think Ms. Batista and the city did an excellent job in coming up with a workable balance, the most workable balance that could be struck under the circumstances. And it is unfortunate that the release of these imagery, it's unfortunate that it will make it onto the internet. It will be splashed across news articles, and it will cause the victims' families distress. That, unfortunately, is what the statute seems to require, at least as I read it, and at least as I understand the facts at issue here. Maybe this is maybe the statute to be changed. Maybe the Idaho Supreme Court has to clarify the interpretation of it. I don't know if this dispute is going to be resolved here, simply by virtue of the fact that we are talking about a statute that seems to have perhaps unintended, perhaps intended negative effects when we're talking about murder investigations. And I mean, I think I cited this in my brief, but some other jurisdictions have laws that specifically, it would appear, address this exact scenario where investigatory records, whether they involve murder investigations or not, they are generally not subject to disclosure. They're very limited. Pennsylvania has a statute that does this. Idaho, for good or for ill, does not appear to. We are simply, and by we, I mean myself, my office, and the city of Moscow, are simply trying to deal with the competing interests that the statute has created and do what we can to balance the public interest in getting sunlight being the best disinfectant versus the very understandable concerns of any number of families of the victims. And so, Your Honor, if you have any questions, I'm happy to answer them. And I would also point out that if Your Honor needs additional time to craft a ruling, if Your Honor needs additional briefing, Ms. Batista and I have covered this previously. We would be happy to leave the temporary restraining order in place for a limited period of time, simply to allow any additional briefing that the court considers necessary, or simply to allow the court to make a informed, full, and reasoned decision. So just throwing that out there. But if you have any questions, I'm happy to at least attempt to answer them.
All right, thank you, Mr. Glasgow. I do have a couple of questions. So the city, as I understand it from the declarations that were submitted, has responded at least to 2 different requests for this information. The first of the photographs that were blurred, the city did that that was prior to this case being filed. The city took it upon itself to blur the faces. It redacted personal information for witnesses and other non-law enforcement individuals. They blurred bodies, they blurred photographs within the rooms and other items within the rooms, and then also VIN information on a number of vehicles, license plate numbers, including for vehicles that belong to the victims, or the deceased, I should say, in this case. The reason I believe it's incumbent that we use the term deceased as opposed to victims is because there are other victims in this matter. And I think that being identified as far as the criminal proceeding goes and how that definition applies across whether it's a constitutional protection for those victims that are named, but also under Title 19 that both counsel have pointed to. So one of the questions that I have is in responding to those requests, initially, and then also subsequently after the temporary restraining order was issued, which at that point was very limited in what this court issued. That being that the city was restrained at that time from releasing any additional audio, video, or photographs or images concerning or related to specifically Madison Mogen's bedroom, no one else's. The city then released a body cam video with utilizing black boxes over all of the bedrooms within the home, not just the decedent's and not just Ms. Mogen's, as was ordered by the temporary restraining order, and also muted certain audio within that. So my question is for you, the city has to justify, obviously, as you know, under the Public Records Act, the city has to justify those kind of redactions when it's responding to a request. What was the justification for that, or what statutory basis did the city use to respond to those requesters and say, this is why we are blurring these images?
My understanding, Ms. Batista can correct me if I'm wrong, but my understanding is that we relied on your order, and the fact that Mr. James had indicated to us that he was intending to bring claims on behalf of other, and I apologize for the imprecision in my usage of deceased and victim, Your Honor. But my understanding is that the statutory basis, I don't know if there's a specific statutory basis that the city relied on other than to say, we have a court order that says we can't release bedroom imagery of this victim. We have a plaintiff's counsel who has indicated that additional parties are coming. It was abundance of caution. I think that if we had gone the other route and simply redacted Miss Mogan's bedroom with black boxes and nothing else, I'll be frank, I would not want to be back in front of Your Honor arguing and explaining why, when we knew additional plaintiffs were coming and were going to be added, and as it turns out, only one was, why we defied, if not the letter of a court order, but why we defied the spirit of a court order that clearly had found that bedroom imagery was potentially problematic. Rock in a hard place, Your Honor. That was the basis on which we released that body cam video with those particular redactions of all of the bedroom imagery or any descriptions of the bedrooms. Again, Ms. Batista can correct me if I'm wrong, but that is my understanding of what the basis was.
But what about, I guess I'm asking, before any court intervention, the city released images to, as we know, KTVB, I believe was the requester, that have been disseminated. I don't know who or how, and that's not even part of the analysis here. It doesn't matter, but they are widely available on the internet. Though the city made a decision at that point in time, based upon their statutory duty to respond to a public records request, that they were going to blur certain things, which I went over. There was no court order in place. What I'm wondering is, what was the city's justification? What were they using to justify that blurring or redaction of the images at that point in time? Was it this provision, the unwarranted invasion of personal privacy, or was it something else?
Ms. Batista, you're on the call. Would you like to address that?
It was based on the unwarranted invasion of personal privacy.
Okay. So then my next question is, if that was the case, whose privacy interest was the city asserting? And was it that it was an unwarranted invasion of the personal privacy of the deceased person themselves? Or is it of the family members of the deceased? Do the deceased individuals maintain a privacy interest in their body, their blood, their effects, their personal identification, the VIN on their vehicles, the license plate numbers on their vehicles? Because those were blurred. So is the city maintaining then, if the family members do not have a claim or a privacy interest under this particular exception, is it the deceased person? And how far does that extend, Mr. Pliskov?
Well, I think that, we're getting into an issue that Mr. James got into as well, which is whether and to what extent there is an attendant interest beyond what the deceased has. I think that there is undoubtedly, whether in Idaho or elsewhere, a common law privacy interest. Fabish, the United States Supreme Court decision, talks about that, at least in general terms, maybe not specific to Idaho. But I don't know is the simple answer, Your Honor. It is difficult to say. The statute that defines what an unwarranted invasion of personal privacy is seems to suggest that it is a narrow interest that inures to the benefit of the deceased only. That's the only one they're talking about there. There's no mention of family members. There's no mention of other interested third parties. And yet, I mean, you can look to other provisions of Idaho code and find language that seems to suggest that victims have some sort of interest that might apply here. I think that I think the court has to go by what the specific statute says here. Specific derogates from the general. The specific provision we're talking about here is the specific statutory language that governs the release of public records. And to govern the release of public records, this statutory provision talks specifically about what is an unwarranted invasion of privacy and not. And that's the term you have to look at. Looking elsewhere to terms that are not referenced, the legislature could easily have cross-referenced these statutes and said, this is what it is defined as for these purposes, subject to the limitations set forth in statutory provision X or Y, or in addition to the provisions set forth in statutory provision X or Y. That's not what the statute says. That might be what it should say, but that's not what it says. And to the extent that we are talking about the redaction of private information of what would be VIN numbers, other personal identifying information specific to the deceased, I wasn't involved with the additional redaction process, so I will freely admit that I might have to turn it over to Ms. Batista on this, because I hate to throw her into it, but the exact basis on which these were released is she is much better versed in the analysis and the thinking process that went into that. So, Mia, if you would like to address this, if you can address this, please do. Otherwise, I will attempt to muddle my way through the city's thought process.
Your Honor, if I understand part of your question, it was, involving the redactions of the vehicles in the parking lots and the VIN numbers. There are sections within the Idaho Public Records Act that allows you to redact personal identifying type of information. When reviewing those, we felt, in part because of the way these materials were being shared nationwide, really, that not knowing exactly who those vehicles belong to, what could be done with that sort of information, we erred on the side of trying to protect whoever the owner of those vehicles would be, trying to protect their privacy interests. And that's why we redacted those. I'm trying to find the exact section, but I'm not able to find that right this second. But there is a section that allows you to redact personal type of information, identifying information that would include things such as, financial account numbers, social security numbers, driver's license numbers, certain information within a driver's license number, and things of that matter.
So I guess another question I have then, going on this same line, is that if we are to interpret the statute as Mr. Pascal, as you've indicated, and following your briefing, and saying that it doesn't specifically say that the family members have an interest, a privacy interest. In subparagraph 17A, Roman numeral 2, it says that the disclosure or release of information is likely to violate legitimate and substantial privacy interests of the person identified when such interests are weighed against the general public information. If Mr. Pascal or Ms. Batista, if the court limits the interpretation of the person identified being the decedent themselves, then, and the city were to release images, video, not blurring, not redacting, just showing the dead bodies, what's the recourse? The decedent person they're not here to challenge that. So who then on their behalf but the family can? I mean, what's the point in having that particular subsection of unwarranted invasion of personal privacy if it's left to the decedent to try to come forth to claim some interest in saying, you can't release an image of my dead body? mean, that doesn't logically make sense. So I'm trying to understand how we can be so narrowly interpreting it, if that's what the city is asking.
Well, for one, this may be splitting hairs here, but estates of deceased individuals have residual interests. The mere fact that a family member can't bring a claim on behalf of a deceased, but the estate can, is not a concept that is utterly alien to law, whether in Idaho or elsewhere. I think it might be unusual to interpret, a right of survivorship in this context that does not inure to surviving family members, but does to the estate.
So sorry,
but it's not completely unprecedented.
I'm sorry to interrupt you, but are you saying then that what should have happened is that these families should open up a probate and be representatives of the estate of these two individuals, or in order to come and assert? I'm confused on what you're distinguishing.
I mean, yes, I think that is the distinction that I'm drawing, simply to say that if it's a personal representative of the deceased estate bringing claims, that is the answer to your question. I don't necessarily think that it's an unusual result. I will freely concede that, and it may or may not be what the legislature intended. But at the end of the day, it is what the statute says. And I mean, that is where we come down. And unusual, unorthodox, strange though it may seem, that seems to be what, in our view, the statute suggests.
Okay. And so if the court does find that these particular plaintiffs, have a privacy interest, does the city agree that the other deceased victims' families would have a similar interest? Or does the city believe that they should be required, as Mr. James has done here on behalf of two of the decedent's families, filed a suit to assert such interest?
I think that I can only answer the claims of the parties that have filed suit here, but as a general principle, I don't think there's much difference. Yeah, if one set of family members have a privacy interest, so do all. And I mean, there's a reason why the materials, the additional redactions the city has prepared, apply to all bedrooms. So go one, so go all. It's the same thing. And I don't necessarily think that there is any reason why, at this point in this litigation, a separate suit would have to be filed by the additional family members. If Your Honor says there's a privacy interest here and it weighs strongly in favor of X or Y, the city is going to abide by that ruling across the board here. It's not going to sit here and play games and say, well, two families have brought suit, but the other two haven't. So these images can go out, these images can't, and too bad you didn't file suit. I think that we do not dispute that the city has an obligation to apply these statutory exceptions and do so in good faith and to the best of the city's ability. If the court gives clearance and guidance, we might appeal your ruling, but we will abide by it. And if the clear implication of it is that these are privacy interests that apply to all of the family members, and the weighting of the competing interests does not favor disclosure, we're not going to stand on principle or procedure and say, no, two families have voiced their interests, four families haven't. Two images get released and the other two don't. There's no difference here. We will abide by your ruling, whatever it is, Your Honor, subject to potentially appealing it.
Okay. And then, so my last question, Mr. Pascal, sorry, I do just have one more. So the city has asserted, obviously, that the public has an interest in law enforcement's investigation. That is the primary interest that we're weighing against this privacy interest, and whether or not the release would constitute an unwarranted invasion of that personal privacy, as opposed to, say, a warranted invasion of the personal privacy. the videos depict law enforcement's actions, as we know, as far as going into the scene and those things, as well as the written reports that the city has already released or made publicly available on the website. So I am wondering how that public interest is enhanced with images of the bodies, the blood spatter, the blood stains, when all those descriptions are available in reports. How should we weigh that, or the court should weigh that against the privacy interest? I guess I'm wondering, what is the threshold the city sees as the unwarranted invasion as opposed to just a warranted invasion?
I mean, Your Honor, at some level, as we set forth in our brief, it is difficult for us to answer that question. We aren't the party that wants it. It is difficult for me on a personal level to understand why imagery, body cam videos, and what have you, why they are necessary, what clear, legitimate interest their disclosure serves. I'm not the requesting party. The city has 200 of them lined up. If we turn around and say, we draw the line somewhere, it might satisfy some of them, it might satisfy all of them. I don't know. The city might end up defending several lawsuits from parties that are interested and think that the precise imagery that you have just listed off is utterly essential, whether because they have questions about the investigation, whether they have questions about Mr. Kohberger's guilt, whatever the reason may be. We can only speculate as to what that might be, or whether those lawsuits will be filed. At the end of the day, a line had to be drawn, and our understanding is that where warranted and unwarranted lie here, it doesn't end at the edge of one of the deceased's bodies, but it's kind of close to that. Crime scene photographs that show dead bodies are clearly an unwarranted invasion of personal privacy. There's a Supreme Court case that says exactly that. Justice Kennedy talked about it at length. We do not dispute that. However, body cam videos, photographs, other records that were compiled during the course of the investigation that are careful to omit imagery of the bodies themselves, that show how officers processed the scene, that showed how officers investigated the crime, and that dispel beyond, in my view, any possible basis to question that this was a properly run investigation, and there is no reason to doubt the guilt of the party who has admitted that he committed it. I think that it is nothing short of conspiracy theory that gets into why these materials in any form, redacted, any form greater, I should say, than, all right, let me back up that just a second. I do not see how anything other than conspiratorial interests would support the release of imagery and body cams beyond the version the city initially prepared and that initially provided to the court for its review. I also don't see how the city can reliably stand up in front of a judge, whether it's this judge or another court, in an action brought by a requesting party saying, we need this imagery. We think that it has these redacted photos with these black boxes that the second set of redactions prepared by the city, or something in between. We don't think this is enough. We think these are investigative records. We think we need them to prove or disprove what we think are our understanding of how things went down. Bottom line, as I said, Your Honor, a line had to be drawn somewhere. And if the city came down slightly on the wrong side of the balance, I don't know what there is to say other than we will accept Your Honor's assessment of where the proper balance lies. We might appeal it. We will, however, comply with it. And we are talking about, at the end of the day, concepts of warranted and unwarranted. I mean, Your Honor has been on the bench for a long time. Warrants, reasonable suspicion, Fourth Amendment. These are not standards that are amenable to mechanistic, clearly defined, easily applied in all circumstances definitions. Courts have been wrapping themselves in knots since the beginning of our country, trying to define what is reasonable suspicion, what is probable cause, what is a warranted intervention, what is an unwarranted intervention. And I don't know what else I have to say other than we think the line was appropriately drawn by the city in this case in the initial set of redacted photographs and videos that it released. If Your Honor disagrees, we will move from there.
All right, thank you, Mr. Pascal. Mr. James, any reply?
Your Honor, Your Honor asked some very good questions there of all of us. And I think it's important to look at what the city did as opposed to now necessarily what it's arguing. Before all of this started, the city released to KTVB these images and redacted the bodies. And they redacted well, I should say they blurred, to be consistent. They blurred the bodies. And why did they blur the bodies? In their view, it was redacting the bodies. And why did they do that? I think one can reasonably infer the city did that because they believed the exceptions within the statute applied. That's why they did it. And Mr. Pascal has candidly just admitted that, under the Supreme Court analysis, that the Desian images are an unwarranted invasion into personal privacy. So I think, look at what the city did. It followed the statute, it thought, by redacting those images, which means the privacy, it's an unwarranted invasion of personal privacy to show the images. The question then becomes to whom. We would assert both for the decedent and for the immediate family members. But the reality is they interpreted the statute the way we're interpreting the statute. That's why they did that. Now, the subsection of the statute and the relevant language, the city argues, you need to follow the statute, but what they're really arguing is you need to follow our interpretation of statute. And the court ultimately needs to determine what these words mean. But the term used in the statute is somewhat ambiguous. It says disclosure or release of information is likely to violate the legitimate and substantial privacy interests of the person identified when such interests are weighed against the general public information. So what does the language of the person identified? Well, one can interpret that to mean the person identified is the person whose privacy interests are being violated or coming forward. And that's reasonable. I'll illustrate why. This doesn't just apply to images. There could be a person who's in the image that is not the decedent, and it's like the example I gave of the naked girl. It's an unwarranted invasion into their privacy, and this is the mechanism for them to assert it is it's an unwarranted invasion on the person identified, and it could be a person who's not the person the picture was taken of, whose privacy interests are being violated, is my point. And probably the girl example isn't the best, but there are situations where there could be information that's disclosed that shows one person, but it violates the privacy rights of another, maybe the wife or husband. A disclosure of certain images or information about their spouse may be an invasion of their privacy too, and they have a right to assert it. So I think the court can interpret that statute to apply where the privacy interests of the person identified are the people identified are the people bringing the claim here. And also, I just remind us not to forget that there's a common law right of privacy out there, which standing alone, I think, is a basis to grant the injunction. So thank you, Your Honor. In sum, I think the city's actions already answered the central question here. There is a privacy interest. There is an unwarranted invasion. The real question gets to be this balancing test then. And I think that's where Mr. Pascal was going when he said several times, in end of the day, you really get to this balancing test. And I'll just say a few words on that. there is a balancing test, and we recognize the importance of transparency in government, and we recognize the importance of the policies underlying the statute regarding disclosure of information that's not subject to the exceptions, and we understand that. I will contend this is a unique case with the worldwide attention, and because we're at an inflection point in technology and an inflection point in this true crime phenomena, that has all collided to make this, I think, a unique case. And how that fits into the analysis, I think, is something for the court to consider. But when you look at what these images would show, the dead bodies, I mean, what more do we need to know? The autopsy reports, for whatever reason, are already out there. If you want to know how many times each child was stabbed, just go read the autopsy reports. They're circulating everywhere. If you want to know how gory the scene was, you can read all that. I think that was partly what the court was looking at. And some of the questioning is, this information is already available out there. Do we really need to put gory images of bodies and blood, which is part of the body? No matter how that's argued, it's part of the body, to put it out there in the world. Under the unique circumstances of this case, no, because there's already so much information out there. You can find this stuff elsewhere without having to look at these images. So in conclusion, Your Honor, I think the city has already admitted that the statutory unwarranted invasion of personal privacy interests apply, because they've already interpreted the statute to redact images before any of this got started. And the question then gets to be, where's the line for the court? And I think the court has already found that the death scene images are over the line. We think some audio and some other images are over the line. And we respectfully ask the court to enter the permanent injunction. Thank you.
All right, thank you, Mr. James. All right, thank you, counsel, for your submissions, including the briefing on this. I am going to take the matter under advisement and issue a decision. In the meantime, the temporary order that is in place specifically was in place until an extension is granted or the order is vacated upon further hearing. The temporary order will remain in place pending the court's decision. I am going to issue an amended temporary restraining order, however, because the original order did just prohibit disclosing any images, audio, or video depicting the inside of Madison Bogan's bedroom. Given the additional plaintiffs in the matter and the city's agreement at this point in time, based upon the argument presented in answer to the court's question, that if the court does find there's a privacy interest ultimately for these families, that privacy interest would extend to the other, at least decedents, victims' families, without filing a suit in the matter. I'm going to just extend the temporary restraining order to include that there wouldn't be any disclosure of images, audio, or video depicting inside of Madison Bogan's bedroom, I am going to say at this point in time, of the Madison Bogan's bedroom, Haley Gonzalez's bedroom, which was also black boxed at one point in time, and then Xana Kernodle's bedroom, in which Mr. Ethan Chapin was located. At this point in time, just so that there aren't any additional release with those things until we can get at least a final decision here. Quite frankly, I think the court has made clear in its temporary order decision that was issued on August 15th that I think we are really looking at the death scene images, whether or not those should be released, and if so, to the extent of which, whether they're blurred or otherwise redacted, what that is going to look like so as not to cross the threshold of the unwarranted invasion that's being asserted. But again, I thank counsel for your time here this morning, as well as your briefing on the issue and the declarations. I will take the matter under advisement and we will be in recess for today. Anything further, Mr. James, in this matter?
No, on behalf of my clients, we thank the court for the judicial guidance the court has provided and the riveted attention the court has given to this case and the expedited nature of the case. And we are grateful that the court, however it comes out, we are grateful for the court's judicial guidance.
All right, you're welcome. Thank you, Mr. James. And Mr. Plascal, anything else on behalf of the city here today?
I would just like to thank you as well for your time and your attention to this matter, Your Honor. And that is all. Thank you.
Thank you. We will be in recess.
Okay, I don't know if everything's okay with CJ because it got frozen, and I was waiting for it to. Oh, you're still here. Good.
Yeah, I didn't
Okay.
realize my StreamYard's having issues with my camera, I guess.
Oh yeah, it might be the VPN as well. It makes things a bit slower, but it worked. It still worked.
Mm-hmm.
Yeah.
I'm exhausted after that.
Right. So, yeah, I definitely think that she's gonna go with the families. I mean, obviously she's taking it under advisement. We're not in her head, but I think she is leaning towards the families.
It seemed like that from the start.
Yeah.
I don't know. I've never heard a judge go, were you wanting this included too? I never heard of a judge do that before, and she did it multiple times in that, and so it's pretty obvious what they can. I just don't understand why they, with the technology and how many megapixels are in a picture now, to say that you can't redact just Maddie and have the picture of the sheath wherever it may be. I don't understand why that couldn't happen. It's a redaction.
Yeah. And I mean, here what Yogi's saying is true. They're not actually like getting to that topic of the sheath. They're talking about, they're like, it's implied, but they're not really just like facing that topic. And that is the major concern of most people. I mean, the argument that blood is still part of the body.
Yeah, you can Google crime scene and see it all already. It's nothing new. And I almost got the feeling like they were just trying to drag out the time to, make sure I hit that paywall. That's what it seemed. It seemed like a lot of re-saying stuff you've already said over and over and over, and then the judge, hey, do you want this included? Well, judge, we can't answer for other families. I mean, it's a lot of stuff that was just like, we're wasting a bunch of time just to try and drag it out, maybe to make sure we get that next tier of payment for our services that day. It really could have been wrapped up in 10 minutes, honestly. I don't see why it took that long.
Yeah, no, I know what you mean, but I don't know. I don't know. I feel like it could be a really serious issue if that's taken seriously. I mean, like I said in the beginning, I don't want to undermine what the families are going through, but I do not agree with their lawyer. That's all I'm gonna say.
No, I mean, you can literally Google crime scene and you see you see it all, and literally, now we have the technology where you can zoom into a photo so close and literally change that color of pixel to just black, and there's your redaction.
Well,
and if they
sorry, go ahead.
They want to bring up about how they don't want people on social media and the public to create more conspiracies. Well, if they're going to refer to how they know what the public does, well, then if you know what the public does, then you would know that the public is talking about the sheath. So why didn't you talk about the sheath then? It's trying to
Exactly.
pretend to be informed for an argument when really you're not informed. That's how I
Yeah.
took it.
Yeah, exactly. And I mean, what I think is really dangerous about what they're trying to say there, and I'm coming back to this thing of whether blood is still part of the body or not, is that they're gonna say that there was blood on the sheath, so that they just have to redact everything.
It's
And I mean, I think it's very unreasonable, but we'll have
yeah.
to wait and see.
That's
Yeah.
why I said you can go back to when cameras were invented. Oh shoot, better not look at Jesse James in his coffin anymore.
Right. Yeah, I don't know.
I mean, like you can literally look up like from when cameras are invented. And then especially with all of these crime scenes and all these other cases, what if we never, it's going to be dangerous. I don't think like Idaho's its own freaking place. I don't think anything that Idaho does is going to set some kind of standard for the country. And because honestly, like if 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 our court system was literally able to make sure like everything was redacted, even blood, then how are we supposed to question evidence in any of these other questionable cases? Ellen Greenberg, you know, uh, uh, Sarah Birchmore, right?
Right.
You've covered that. Like, if we weren't, and we don't have to see the body, but to say
No,
that you can't see blood, that
it's dangerous.
no,
Yeah.
I mean, I feel bad for the people in Idaho because I feel like it's going to set something in Idaho, but I don't see the rest of the country going, yeah, because Idaho did this, we're going to do this. I think Idaho's going to be in its own boat, but it's just sad because
Yeah.
it's having bubble wrap. You need bubble wrap to go outside. You can't we don't want you to get a bruise, Jimmy, so put on some bubble wrap, I mean, come on.
Yeah. I mean, it would be bad enough if it set precedent in Idaho, but I'm glad you think that it wouldn't, have that domino effect.
I don't think so, because the rest of the country is going to be like the same thing we're saying. We're not 1900, dude. You can Google crime scene and see blood everywhere on whatever crime scene, and it's important because just think of all the cases, right? Just think of all these cases. If we weren't able to even see the blood in photos and question the evidence, how many of these cases it would just, there would be no checks and balances, in my opinion. And then
Yeah.
they could just do whatever they want and tell you that blood was there, even though they don't have to show it. That is so dangerous, man.
Yeah, and the reverse, I can tell you that it wasn't there when it was. That's equally as
Yeah.
dangerous. Yeah.
You can
But
you can redact a pixel anytime. That's what should be happening. Both sides get whatever, because nobody's asking to see the bodies. I mean, I'm not, but do we need to see the blanket if it's got blood on it? I'm sure it does, but do we need to see the blanket with a sheath? Yes. Can you literally ... every part of Maddie? Yes, there you go. Because nobody's looking for it's the sheath.
yeah. Yeah, and I mean the body cam that they're referring to, I'm assuming, it would be the continuous one from, sorry, just kicked the table there. It would be the continuous one from, when, I think when they found the sheath is something that people are particularly interested in. But I think that even just a photo of the sheath would suffice.
Yeah.
Like,
Just
we don't need to see the video.
you can crop everything else out. I mean, think of it's digital. Oh my gosh, brain fart. I do it all the time with my stuff. What is that? The where I do my art stuff with my layovers and all that. What's that name for it?
Like graphic design?
Graphic design, yeah. Any graphic designer can do that. I mean, Hell, I just made up a graphic. You saw it, the one I posted in our mod chat, you know, with the dude sitting on the toilet. I mean, hello, you can literally crop out whatever and zoom it in and everything and make it just you no body and that's it. I don't
Yeah.
understand. It
Yeah.
doesn't make sense to me.
Let me just check this comment. I think we should focus on the witnesses, not the bodies. I understand what you mean, Lori, but I think that looking at anything in isolation in an investigation is always a problem because everything is linked to something else. So having a broad overview of everything will like help you to understand stuff. So I know that there's stuff about the witnesses that people really want to know more about, but there could be something in those facts that connects to, you know, the pictures and possibly the bodies. But again, I maintain that I'm not expecting to see pictures of the bodies.
No,
Yeah.
never did. But the sheath, yeah, because that what's the biggest question that we've had this whole time since it started when we found out the sheath and they saw it through the door? Well, how did you see the sheath laying underneath Maddie under a blanket when Kaylee's laying on top of her and you can see it from the door? That's been the biggest question from the beginning when the PCA was dropped.
Yeah.
And still that's the biggest question. That's the only question that, to say that, that I don't listen. I see ugly stuff. I'm sure you do as we're digging into these cases that we cover and research and stuff. You come across it, but it's not like you need to see it. You don't need to see somebody's brutalized body. You don't have to. You need to see the evidence. And when it comes to the witnesses, we already knew who the witnesses were. So for them to want to, you can redact their face if you want. We already know who they are. But to try and redact their audio, well, then that means that 911 calls are always going to be redacted from now on, too. And so if you include 911 calls getting redacted, and then you also include never being able to see photos of evidence without any blood and all that gets redacted, well, then what are we going to be able to do as a society when it comes to challenging the propaganda that is given to us?
Yeah.
That's why we're
And-
here,
And that also, like, that can be pushed further into witness statements and interviews as well. It's not just stopping at 911 calls.
Right.
So it'll just snowball into everything. And look, I can come from a different perspective here. I come from a country where we don't have access to, we can't do a FOIA request here. It's something that's very unique to you guys. I could never go and put in a request. It's not the same. And I think that it's something that it makes you guys, it makes your system what it is. And it's something that I think should be protected. It's not, like I said, I feel like it could snowball into.
Yeah. It's checks and balances.
Yeah.
Because like you look at just throughout, like when countries were even created, when there's no checks and balances, things run amok. And it's usually a negative muck. It's never usually a positive muck. And
Not a good muck. Yeah.
You think that we would learn, but I don't know. It's just dangerous. It really is. When it comes to the Kobe Bryant stuff, that the stuff where the sheriff was sharing pictures with people at a frickin' bar, that he personally took on his own device. That is, you're sick, dude. Like, you're sick to do that. Because and if you know the injuries that Kobe Bryant sustained during that helicopter crash, I can't even imagine the pictures, because literally he had one limb left and half of a head. All right. It was bad. And to imagine somebody like sharing that kind of photo is disgusting. And I understand that, that case there. And nobody should see these, have I seen the helicopter and the damage to the helicopter and everything without the bodies? Yes. We don't need to see the bodies. Because some people might not be able to handle it, honestly.
Yeah.
You may think you can, and then you come across something like that, like Kobe Bryant's body, for instance, and then you're just like, it's stuff you don't forget. So
Yeah. Yeah, and that's also a good point. I mean, they are speaking about it from the perspective of protecting the victims and the deceased, but it is also part of protecting what people are going to see and whether or not they can handle it. So I mean, I completely understand that. The situation with the blood, I just don't understand. I actually really agree with that. What was his name? Pascal? I think that the city did do a pretty good job of trying to balance. Yeah, they did.
I mean, some of it was a little ridiculous, like when the officers are going in Xana's room and they block the whole door. You can block just the bodies, you know what I'm saying? So they I mean, in my opinion, I thought the redactions were a little heavy.
Yeah, me too.
On that body cam. So, but I was fine with it. I mean, you got to me, you got to see how law enforcement didn't know how to handle the crime scene. Like you're going back and forth from the house to the witnesses, and you're not separating the witnesses, and you're letting them hang out in the street, and you're going back and forth into the house, outside, into the house, outside. And then the people that are inside, you got main dude with the stash walking around, no latex gloves on or nothing. And he's touching handrails and doorknobs and all sorts of stuff, and I'm just like, wow. You got to see like how they literally didn't even know how to handle the crime scene. It was very sloppy, and it was just as sloppy as it was outside.
Yeah. I mean, I think, and I mean also that is important. It's not necessarily just for like the way they're making it seem like it's for, people on the internet so that they have content. Like there's a real reason for it,
Yeah. They tried to be informed. They were just listening to Bill Thompson, what he said in the press conference when they arrested Kohberger, and he was telling people on all the socials to read it, It's what they're interpreting. Now, is there a lot of people? Unfortunately, that's the bigger fish of the platforms that do that. You just had somebody, a bigger fish on the platform, is claiming right now that Emmanuel's location is found and that he's buried, and then you listen to it and it's a Brian Enton story from yesterday, and you see what I'm saying? Like people will. That's the bigger fish get, they are about the clicks, and they get the clicks. And so people in Idaho probably aren't coming across the down to earth, common sense, respectful about the victims, families, and communities chats, because we're not pushed out in the same algorithm as the clickbait is. And I can see how they get that, but at the same time, if they really did their research, they're just listening to somebody else that said that. Because if they really did their research and they did go around, they would see, oh, they're talking about the sheath. So why don't we discuss the sheath the whole time? And I mean, because that's what it's about. It's about Maddie's body, and it's about the sheath. If you're going to say that seeing a blanket with blood on it, obviously it's going to be triggering because that was the blanket that your loved one was next to. but I can guarantee you that you've seen pictures of the same sort before.
Yeah.
And to say that you know what I'm saying, like that, it's okay until it's your own, and then it's like, well, wait a minute, what about all these other people? How many, like, can you imagine these families if they have these questionable cases where evidence doesn't make sense and their loved one is not getting justice, and they're trying to, you know, like Ellen Greenberg's parents specifically, they're out there trying everything that they can to get people to see the evidence so they can, it's more awareness about it. I can't imagine if we ever have a day in the future where a family can't even get, if they want to, they can't even get that stuff out to the public because of some kind of restriction on blood. It's just wild.
Yeah.
I don't get it.
Yeah. I just want to answer one question of Yuri's. Didn't part of the blackout include law and crime on it? So it gave the indication that law and crime blacked it out. I don't remember. I don't remember seeing whether the blackout was over the logo or not. The only thing
No,
that
it
I
wasn't.
remember, it wasn't.
The logo was over the blacked out parts.
Oh, okay. All right. Well, then, and I mean that video came out after the temporary restraining order, so they would have like revisited how they were going to do it. Otherwise, it would have probably been like a violation of that. The photos that came out after the temporary restraining order were ISP photos, so I don't know if they are affected by the restraining order, but the only thing that I remember was when the first batch of photos came out, I was watching all the media because I was taking screenshots of their coverage to get the actual pictures.
Yeah.
Some of them did say that they were reviewing the pictures to see what was too graphic. So I did get the impression that some of the earlier pictures were blurred by the media, but maybe not all of them. So yeah, but the body cam was definitely after the temporary restraining order, because I remember being really surprised that they even did that. I was like, okay. It was like the next day or something. So
Yeah, I remember when the Law and Crime was the one that first dropped it, and I was scouring all the sources and all the different webs trying to find another source that, whoops, I'm sorry. Trying to find another source that didn't have the frickin' Law and Crime thing flying over it, because it's like, I don't know, that right there kind of bugged me a little bit, because I'm like, it's already not your production of it. So why you got a logo flying over the place? But I think it was because they did have exclusive access first to it, and that's why they went ahead and did it, because usually they won't do that. But with that one they did, and
they really did. Yeah, they
Right.
were very thorough there.
Yeah,
Yeah.
you like literally had to time it right sometimes just to not have the logo in one of the photos or part of the body cam, because it just kind of, it was a little too transparent as well. It did cover up some things also, and so yeah, I was trying to find another one and I couldn't, and so I don't know, to me, I just assumed that that's how they got it. I don't see law enforcement giving them a copy that they themselves would have to redact, because I feel like if they did have to do that, I don't think Court TV would barely have redacted anything, honestly.
Yeah, I don't think Court TV redacted anything.
Yeah. I think they would have left more. They would have maybe blurred where the, kind of like what I was saying, just blur where the bodies are at. I think that's probably where they would have went if they had the choice of what to blur. But I don't ever see law enforcement given any kind of documentation expecting somebody else to redact it, especially mainstream media, because we already saw the limits that they're willing to go to against the wishes of the judges. So
Yeah. Yeah. I mean, there's still the leak that we've kind of all forgotten about. Yeah.
Captain Champs.
Did you see he wasn't on the witness list?
Right. You know why?
Yeah.
Yeah, because they told it's. I told you. I told y'all a couple years ago. December 16th is when they asked him to step away.
Mm-hmm. He
That's
was the
just my
first
opinion.
name I looked for. I was like, "Where's Tyson?" And he wasn't
Yeah. No, he wasn't.
Yeah.
It was all by design, Rosie.
there. Yeah. All right. Well, I think I'm gonna end the stream there. I'm very pleased with myself. Like it worked. It worked with the VPN. So I'll be able to do this a little bit more. Yes.
Thank you. I appreciate you.
Thank you so much for coming. Thank you everybody who watched, and I will see you guys soon. I hope you all have a great day.